A or B of the Emergencies Act concerning a national emergency had been met. C, the situation could not be effectively dealt with under any other law in Canada as required by Section 3 of the Emergencies Act. D, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that these documents shall be deposited with the joint clerks without redaction and in both official languages within 10 days of the adoption of this order. B, in relation to the translation of commission evidence, the committee invite the following witnesses to appear separately for at least 1 hour each. A, senior officials from the Privy Council office, and B, other witnesses representing parties which placed unilingual submissions before the commission or entities whose unilingual evidence was before the commission, whose names are provided to the joint clerks by members of the committee within 10 days, and 2, members of the committee shall, within 10 days, identify their preliminary lists of unilingual commission evidence or submissions for priority translation to the joint clerks who, in turn, shall relay those requests to the Privy Council office. C, to accommodate the scheduling of witnesses, the committee meet during the weeks of March 4 and 11, 2024, if necessary, and 2, if the number of witnesses proposed under clauses A1H and B1B warrant, the joint chairs shall convene a meeting to discuss prioritizing their respective scheduling. And D, in relation to the committee's draft report, the committee suspend its work on the current draft report. The analysts be directed to prepare a second draft report incorporating the information and analysis set out in the federal court ruling, along with the evidence received under paragraphs A and B. 3, members of the committee may, after the committee has received evidence under paragraphs A and B, submit draft recommendations and conclusions for the draft report, including those which may have been negated by the committee on May 16th and June 6th, 2023, where reconsideration may be warranted in light of the federal court judgment or the evidence received. And 4, the committee work toward a goal of tabling its final report by June 21, 2024. So, Chair, this is a very comprehensive motion. It covers off a number of things, and I believe very succinctly identifies some of the areas where we want to go, or I think the committee needs to go in preparation for a fulsome study of and conclusion to this particular event of the invocation of the Emergencies Act. Now, if we look at the reason why we're here and in following along with the purpose behind our committee, the Mosley decision is exactly some of the areas where we need to cover off. Was this legal? Did they follow the rules of law? Was it charter compliant? Those are all things that we need to examine as a committee. And just for everyone's reference, the federal court, I think, provided a very succinct review. I particularly was pleased with how well it was presented and provided clarity on not just he made a decision, but he provided the rationale for the decisions. And I think they were very, very sound. And I want to take just a moment to just refresh our memory on what those decisions were. So on January the 23rd, the Honorable Justice Mosley of the federal court issued his decision. So 4 groups applied for judicial review of the decision by the Governor General and Council to declare a public order emergency under the Emergencies Act. The February 14th, 2022 proclamation declaring a public order emergency and the enactment of temporary special measures in order to deal with protests in various parts of the country, which included the occupation of the downtown core of Ottawa, and blockades of ports of entry were under review. This was the first time that the Act was invoked since its enactment in 1988. The proclamation, the Emergency Measures Regulations, and the Emergency Economic Measures Order adopted under the Act had a threefold impact. A, they prohibited a range of activities relating to protests in designated areas. B, they required third parties to assist the police in ending the protests. And C, they authorized financial institutions to disclose information on designated persons and entities to federal officials to suspend their accounts. The applicants and parties raised issues which led to the following questions. One, was the proclamation unreasonable? With respect to the first question, the court considered the decision under the reasonableness standard of review and concluded that the answer was yes. The proclamation was unreasonable and illegal, ultra vires, which is really a term that means to act beyond one's authority or power. While the court recognized the occupation of downtown Ottawa and the blockades of the ports of entry were matters of serious concern, calling for government and police action, the threshold of national emergency required by the Act was not met. Under paragraph 3A of the Act, a national emergency is an urgent and critical situation that exceeds the capacity or authority of the provinces to deal with it, and that cannot be effectively dealt with under any other law in Canada. The proclamation applied the temporary special measures in all of Canada, in all of Canada's provinces and territories, despite the lack of evidence that it was necessary. Apart from the situation in Ottawa, the police were able to enforce the rule of law by applying the criminal code and other legislation. While the conclusion of the proclamation was illegal, it was sufficient to dispose of applications. The court addressed the other issues should it be found to have erred in its finding on the first question. The court considered the threshold for threats to the security of Canada. Section 2C of the Canadian Security Intelligence Services Act defines threats to the security of Canada as activities directed towards or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective. Under Section 17 of the Emergencies Act, the Governor and Council required reasonable grounds to believe that the standards set out in Section 2 of the CSIS Act had been met. The evidence in the record before the court did not support a finding that the impunged activities reached that threshold. The second question that was asked, did the powers created by the regulation and economic order violate sections 2B, C, D, or 7 or 8 of the Canadian Charter of Rights and Freedoms? And if so, could they be saved under Section 1 of the Charter? Now, concerning the Charter, the court found that the regulations infringed the guarantee of freedom of expression under Section 2B, as they were overbroad in their application to persons who wished to protest but were not engaged in activities likely to lead to a breach of the peace. The economic order infringed Section 8 of the Charter by permitting unreasonable search and seizure of the financial information of designated persons and the freezing of their bank and credit card accounts. The infringement of Section 2B and 8 of the Charter were found to not minimally impairing and could not therefore be justified under Section 1 of the Charter. The court found that there was no infringement of the rights to freedom of assembly, and so that particular piece of the Charter was not found to be a breach. Now, I think it's important to recognize that while Justice Rouleau had a role to play in his presentation of the evidence, we don't have a lot of the 250,000 documents that he said he saw. We're never going to see all of them, but he relied on 7,000 documents to write his report. And so I think it's important that we, some of the words that he used in his justification for his decision, Rouleau, to support the government's invocation was the evidence was underwhelming, and that any other person presented with the same evidence could reach a completely different conclusion. So it didn't leave me with a lot of confidence back in the day, and I've spoken that at this committee, that his decision did not leave me confidence. On the other hand, Justice Mosley's decision from a high court in this country has provided to me confirmation that there was an appropriate judicial review of the act and the use of the act, that it was found to be illegal in this circumstance, and that there was a breach of the charter. So it begs a number of questions. Our role as a committee is to do a number of things. One of the things that that Mr. Beattie, our very first witness of this committee, told us, he said, we need to ensure that the act is, that our role is to look at the act and ensure that it is adjusted to ensure that no other government can present or invoke the Emergencies Act under the exact same circumstances again. And beyond that, we have asked for charter documents, a charter analysis that we never got. It was a trust us, we've done it, never did see it. And the other thing that Justice Rouleau made a comment about, that it was unfortunate the government chose to keep their broader interpretation to themselves. And Mosley speaks about that a number of times in his decision, that we're just supposed to trust them. Well, you know what? The Canadian public has lost trust with this decision. And so the motion has a number of different components to it that speak to the need to have certain people here as witnesses, the need to have documents. Again, this is not a new phenomenon for this committee. We've asked for documents that the government relied upon to make their invocation, and we haven't got them. In fact, it's quite telling that the government has refused at all levels to prevent some of this documents to be released, and I think it's unfortunate. The other issue that is before us and was left over from our meetings in the fall was the issue of translation. I don't know how we're going to solve that completely. I think we need to come to some, my personal opinion is we need to come to some compromise on how to make that work and make it work fairly for everyone. And I'm certainly open to conversations about what that might look like. But again, the motion as presented deals with the report as well, and where we need to go with the report and the information we need to include in the report now moving forward, and the goal, with the goal to correct it. I think our longest, as I look forward to our calendar, I think the longest task that we're going to have is developing recommendations that are going to address some of the gaps in the current legislation that we might be able to fix. And we can do that, hopefully, a lot of it as a committee, and then have a report done. And if there's dissenting reports, then those